What would you do if land you legally owned suddenly had an entire neighborhood sitting on top of it, and everyone swore it wasn't yours? I never planned on becoming the center of a land war. For most of my life, property was just paperwork, numbers on a tax form, lines on a map, nothing dramatic. That changed the moment I received a call that rewrote my reality. A distant relative I barely knew had passed away, and in the fine print of a thick legal packet was a single line that stopped me cold. I was now the sole heir to a massive stretch of rural land. Not a house, not a lot, acres. Hundreds of them. At first, I assumed there had to be a mistake. I lived hours away, had never stepped foot on the property, and knew almost nothing about it. But the documents were airtight. Titles, surveys, tax records, everything pointed to one undeniable truth. The land was mine. I paid the outstanding taxes, filed the paperwork, and honestly forgot about it. Life moved on. Months later, curiosity got the better of me. I decided to finally visit the land I technically owned. I expected open fields, maybe some trees, maybe nothing at all. What I didn't expect was pavement, street signs, mailboxes, roofs. Where empty land was supposed to be, there stood an entire neighborhood. Rows of newly built homes stretched across the horizon. Some looked finished, others still wrapped in scaffolding. Fresh asphalt cut through the land in neat lines. I pulled over, heart pounding, convinced I had taken a wrong turn. I checked the address again, then again. It matched. Confused, I walked down the street like I belonged there, because legally I did. Construction equipment hummed in the distance. Signs advertised upcoming home releases. Everything about the place screamed legitimacy, permanence, confidence. No one builds this much without certainty, right? I contacted the local property office the next day, expecting clarity. Instead, I got resistance. According to them, the land had been approved for development years ago. A neighborhood association claimed oversight. A private developer claimed purchase rights. And somehow my name, the actual owner, was nowhere in their story. When I insisted they recheck the records, the tone changed. I was treated less like an owner and more like a nuisance. One official even suggested my documents were outdated. Another implied I was mistaken about the boundaries. But I wasn't mistaken. I had every original record, every updated filing, every receipt proving continuous ownership. And the more I pushed, the more defensive everyone became. That was when I realized something was very wrong. Because neighborhoods don't just appear by accident, and people don't get this confident unless they think the truth will never surface. And instead of stopping the construction, I made a decision that shocked everyone watching. If you think discovering a neighborhood on your land is shocking, wait until you hear what they told me when I asked them to stop. My first instinct was simple: shut it all down. I assumed one phone call, maybe two, would freeze construction until things were sorted out. I was wrong. When I contacted the development office listed on the signs, the receptionist didn't panic. She didn't even sound surprised. She transferred me like this was routine. The man who came on the line introduced himself as a project coordinator. His voice was calm, rehearsed. I explained who I was, gave the parcel numbers, the inheritance records, the tax confirmations. There was a pause on the line, just long enough to feel deliberate. Then he said something I'll never forget. "That land isn't yours." Not might not be, not let's verify, flat certainty. I told him he was mistaken. He responded by listing dates, approvals, and permits as if reading from a script. According to him, a regional housing authority had greenlit the project years earlier. A neighborhood governance group had assumed jurisdiction, and the developer had been cleared to build. I asked for proof. He promised to email documents. When they arrived, they looked official, stamps, signatures, formatted layouts, but something felt off. The parcel numbers were close but not exact. The maps were cropped. The boundaries were generous. That's when I did something that confused everyone. I stopped arguing. Instead of demanding a halt, I asked neutral questions. Who handled zoning? Who signed off on utilities? Who oversaw ownership verification? Each answer pointed to another office, another committee, another layer of distance from responsibility. It was like chasing smoke. Over the next few weeks, construction continued at full speed. Foundations were poured, walls went up, streets were painted, and every time I drove by, I felt that knot in my stomach tighten. Friends told me I was crazy for not filing an emergency injunction. Some said I was letting them win, but I wasn't frozen. I was watching. I started collecting everything, every permit copy, every public meeting record, every tax payment I'd made since inheriting the land. I hired an independent surveyor quietly. No announcements, no warnings. When his results came back, they were crystal clear. The development sat squarely on my property line, not partially, not adjacent, directly on it. Meanwhile, the neighborhood association began circulating notices. Not to me, to prospective buyers. They advertised community rules, future amenities, and long-term stability. Stability built on land they didn't own. One afternoon, I received a formal letter. It accused me of harassment for interfering with lawful development operations. They threatened legal action if I continued contacting offices. That letter told me everything I needed to know. They weren't confident. They were scared. And they believed pressure would make me disappear. So instead of fighting them in public, I decided to let them build every last house. Most people fight the moment something is taken from them. But sometimes, the smartest move is letting the mistake grow too big to hide. I stopped making noise entirely. No more calls, no more emails, no surprise visits to county offices. From the outside, it probably looked like I had given up. Construction rolled on without hesitation, and the development accelerated like a train that had finally lost its brakes. New houses rose week by week. Driveways were poured. Lawns were rolled out in perfect green rectangles. Streetlights flickered on for the first time. I watched families tour model homes, smiling, imagining futures that rested on land they didn't know was disputed. And that was the hardest part, knowing innocent people were being pulled into a mess they never agreed to. Behind the scenes, though, I was building something far more powerful than an argument. I hired a land use attorney who specialized in quiet disasters, the kind that don't make headlines until it's too late. He didn't tell me to rush. He didn't tell me to file immediately. Instead, he asked one question. How complete do you want their mistake to be? That question changed everything. We started assembling a timeline, one that showed uninterrupted ownership on my side and a suspicious gap on theirs. We documented when the land transferred to me, when taxes were paid, when zoning was allegedly approved, and when construction began. The overlap wasn't just sloppy. It was impossible to ignore. Then came the surveys, not one, three, each from a different certified firm. All confirmed the same thing. The houses weren't near my land. They were on it. We pulled meeting minutes from planning boards. In several of them, the parcel was referenced by a shorthand name, not a legal identifier. That shortcut had been copied again and again, spreading the error like a virus. No one stopped to check the source. Meanwhile, the neighborhood association grew louder. They started enforcing rules, parking limits, paint colors, mailbox designs, acting like unquestioned authority. They even filed documentation claiming oversight of the entire development area, including my parcel. That document became the centerpiece of our case, because it was false. Every month construction continued. the liability stacked higher. More homes meant more contracts. More families meant more financial exposure. And every new signature added another layer of responsibility for the people who had skipped the most basic step. Confirming ownership. I was no longer just protecting my land. I was allowing their risk to mature. By the time the final houses were completed, the development looked permanent, unstoppable, untouchable. That illusion was exactly what I needed. Because once something looks finished, no one expects the ground beneath it to shift. And when I finally stepped into a courtroom, they had no idea how much evidence I'd been quietly carrying with me. They walked into court confident, organized, and smiling because they thought paperwork could bury the truth forever. The first hearing wasn't dramatic. No shouting, no gasps. Just polished suits, thick folders, and an air of certainty from the other side that bordered on arrogance. The developer's legal team arrived early, setting up stacks of binders like trophies. Representatives from the neighborhood association sat behind them, whispering, nodding, acting like this was just another routine formality. They clearly believed I was bluffing. When the judge asked for opening statements, their attorney went first. He spoke smoothly about development rights, community planning, and years of approved oversight. He framed me as a latecomer, someone trying to exploit a technicality after construction had already reshaped the land. According to him, stopping the project would be unreasonable and harmful to families. Then it was our turn. My attorney didn't argue a motion. He didn't accuse. He simply asked permission to submit evidence chronologically. The room changed when the first document appeared on the screen. It was the original land title transfer, dated well before any claimed approvals. Next came tax records showing uninterrupted payments under my name. Then certified surveys, 3 of them, each highlighting the same boundary lines in bold, unmistakable ink. The opposing counsel tried to interrupt, but the judge held up a hand. We moved slowly, methodically. Every permit the developer relied on referenced a parcel shorthand that didn't legally exist. Every approval assumed ownership without verification. One zoning map had been copied so many times it no longer showed the full boundary. And the neighborhood association's claim of authority, based on a filing that quietly excluded my parcel until someone later penciled it in. That pencil mark was still visible. When my attorney displayed that page, enlarged on the screen, you could hear the shift in the room. Chairs creaked. Someone coughed. The confidence drained from faces that had walked in expecting an easy dismissal. The judge asked a single question that froze the defense. Can you show proof that the land was legally transferred from the registered owner? They couldn't. Not because it didn't exist, but because it never happened. What followed wasn't an argument. It was damage control. The developer's attorney requested a recess. The association representatives whispered urgently. Suddenly, the word settlement floated through the air like a lifeline. But it was too late for quiet exits. The judge ordered a full review and issued a temporary injunction, halting any further sales or transfers connected to the land. Buyers waiting in the wings were notified. Financial institutions were alerted. Everything stopped. For the first time, the development wasn't in control. They were exposed. And the moment the injunction hit, the real panic didn't come from the courtroom, it came from the neighborhood itself. The court may have pressed pause, but outside those walls, everything was starting to unravel fast. The injunction landed like a shockwave. Within days, the effects rippled through the neighborhood in ways no one had anticipated. Sales offices went dark. Phone lines rang unanswered. Online listings vanished overnight. Families who had already signed contracts started asking questions, and they weren't getting reassuring answers. I began receiving messages from people I'd never met. Some were polite, some were terrified, a few were angry. They all wanted the same thing, certainty. They had put down deposits, planned moves, enrolled children in nearby schools. And now they were being told there was a temporary legal issue with the land. Temporary. That word did a lot of heavy lifting. The neighborhood association tried to contain the damage. They sent out carefully worded notices urging residents and buyers to remain calm. They blamed clerical confusion and promised a quick resolution. But the more they spoke, the more contradictions surfaced. Dates didn't line up. Statements conflicted. And every message avoided one crucial fact: no one could prove they had the right to build there in the first place. Behind the scenes, pressure mounted. Lenders began to worry about exposure. Insurance providers asked for clarification. Local officials who had once brushed me off suddenly returned calls with forced politeness. Everyone wanted to know how deep this went, and whether they were on the wrong side of it. That's when the offers started. First came the quiet ones. A representative reached out suggesting a mutual resolution. They proposed buying the land from me retroactively, as if ownership could be backdated to erase the problem. The number sounded large until you compared it to the value of an entire neighborhood. I declined. Then came urgency. Another offer arrived, higher than the first, framed as a compromise for the sake of the community. They hinted at delays, legal costs, and stress if I chose to continue. I listened. I said nothing. What they didn't realize was that every offer, every email, every recorded call strengthened my position. It showed acknowledgement, an unspoken admission that they didn't have what they claimed. Meanwhile, the review ordered by the judge uncovered more cracks. Approval signatures traced back to departments that no longer existed. Oversight roles that had been assumed but never formally assigned. One document even referenced a land registry code that belonged to an entirely different region. This wasn't a single mistake. It was a system built on shortcuts, and shortcuts don't hold up under scrutiny. As weeks passed, construction machines sat idle. Half-finished houses stared out with empty windows. What once looked permanent now felt fragile, like a set built too quickly for a play that never got rehearsed. They had bet everything on the idea that no one would challenge them. They were wrong. Because when negotiations failed, the court prepared to answer a question no one wanted to face. The question wasn't who made the mistake anymore. It was who was going to pay for it. When the court reconvened, the tone had shifted completely. The confidence that once filled the room was gone, replaced by tension you could almost feel in the air. The judge didn't waste time on pleasantries. This phase wasn't about discovery or delays. It was about consequences. The central issue was simple and brutal. The land had never been legally transferred. Everything built on it existed in violation of that single fact. The defense tried to redirect, arguing intent, community impact, and the impracticality of undoing what had already been built. They leaned heavily on the idea that tearing things apart would cause unnecessary harm. My attorney responded with one sentence that cut through the noise. Harm doesn't erase ownership. Expert witnesses were called. Surveyors testified under oath, walking the court through boundary lines inch by inch. Title specialists explained how ownership chains work and how skipping one step breaks the entire chain. An independent auditor detailed how the same incorrect assumption had been copied across multiple agencies without verification. Each testimony stacked weight onto the same conclusion. At one point, the judge asked the developer's lead representative directly whether they had ever spoken to the registered owner before breaking ground. There was a pause. "No," he admitted. That answer echoed. because it meant they had built first and verified later, or not at all. The neighborhood association tried to distance itself, claiming they relied on information provided to them. But reliance isn't ownership, and assumption isn't permission. The court then addressed remedies, compensation, damages, enforcement. The defense argued for a forced sale, asking the court to compel me to transfer the land at a fair market rate. My attorney objected immediately. Ownership doesn't disappear just because someone else built something expensive on top of it. The judge agreed. Instead, the ruling outlined options, but the power shifted firmly into my hands. The development could negotiate a lawful purchase moving forward, compensate for unauthorized use, and assume responsibility for all legal fallout. Or they could face escalating penalties tied to every structure built without consent. That's when the reality hit them. This wasn't a paperwork error anymore. It was a financial crisis. Every home represented a liability. Every day that passed increased exposure. And every attempt to pressure me now worked against them in open court. I wasn't chasing revenge. I was enforcing a boundary. When the session ended, no one rushed out smiling. Conversations were hushed. Phones buzzed nonstop. Outside the courthouse, reporters gathered, not because of drama, but because of precedent. Because this case wasn't about one neighborhood. It was about what happens when ownership is ignored. And just when they thought the worst was over, the final decision reshaped everything they'd built. By the time the final decision arrived, the neighborhood everyone thought was permanent was standing on borrowed time. The ruling came on a quiet morning. No cameras, no grand speeches, just a formal notice filed into the record that changed the balance of power completely. The court confirmed what had been obvious for months, but impossible for them to admit. The land was mine, and it always had been. What followed wasn't chaos, it was calculation. The developer was granted a narrow window to respond, but the terms were no longer flexible. Any future use of the land required my explicit consent. Any delay added penalties. Any attempt to transfer homes without resolution would trigger automatic enforcement. In plain language, the court handed me the steering wheel. The neighborhood association dissolved faster than anyone expected. Board members resigned quietly. Notices were pulled from community boards. Emails bounced back undelivered. The authority they once claimed evaporated the moment the court confirmed it never existed. Home buyers were informed officially. Some contracts were voided. Others were frozen. Financial institutions stepped in to assess exposure. The same people who once dismissed my calls were now requesting meetings urgently. Developers returned with a new tone. No threats, no pressure, just numbers. They proposed structured buyouts, phased compensation, and long-term agreements. This time they didn't pretend the land wasn't mine. They acknowledged it outright. But acknowledgement came late. Because I had learned something important through all of this. Leverage doesn't come from shouting, it comes from patience. I didn't rush to accept the first clean offer. I reviewed every proposal carefully. I accounted for unauthorized use, legal costs, delays, and long-term impact. This wasn't about punishing anyone, it was about correcting a mistake at full value. Construction machines stayed silent. Houses sat empty. What once felt unstoppable now waited on a single signature that wasn't theirs to give. Eventually, a final agreement emerged, one that reflected reality instead of assumption. Ownership was respected, compensation was comprehensive, and responsibility was assigned where it belonged. When the documents were signed, it didn't feel like victory. It felt like closure. Because the truth is, none of this should have happened. All of it could have been avoided with one conversation, one verification, one signature checked before the first shovel hit the ground. Instead, they built a neighborhood on certainty that didn't exist, and learned too late that land remembers who it belongs to. But the lesson this case left behind went far beyond contracts and courtrooms. Everyone thinks the story ends when the papers are signed, but the real impact comes from what changes afterward. Long after the case was officially closed, its shadow lingered. Local offices rewrote procedures. Approval chains were restructured. Verification steps that had once been assumed complete became mandatory checkpoints. Quietly, without press releases or announcements, the system corrected itself. That was the part no one expected. Because while the developer absorbed the financial hit and the neighborhood slowly transitioned under proper ownership, the larger lessons settled in across agencies and planning boards. Land records were re-audited, parcel codes were rechecked. Oversight committees learned that shortcuts don't just create risk, they create responsibility. For me, life returned to something resembling normal. I didn't suddenly become wealthy overnight. I didn't seek attention. I didn't even tell most people what had happened unless they asked. But every time I drove past that stretch of land, now properly labeled and lawfully governed, I felt a quiet sense of certainty. Not triumph, certainty. People later asked why I hadn't stopped construction sooner, why I let things go so far. The answer is simple but uncomfortable. Stopping it early would have turned this into a debate. Letting it finish turned it into a fact. A finished mistake is harder to deny than a potential one. Those houses still stand. Families eventually moved in. Life went on, but on corrected ground under real authority, with ownership finally acknowledged. The chaos didn't disappear, it transformed into accountability. And that matters, because land disputes aren't just about property. They're about trust. About whether systems protect the people they're supposed to serve, or whether they rely on silence to function. In my case, silence worked against them. I didn't win because I was louder. I won because I was patient, precise, and prepared. The truth doesn't need urgency, it needs evidence. If there's one takeaway from all of this, it's this. Never assume permanence equals permission. Just because something looks official doesn't mean it's legitimate. And just because everyone agrees doesn't mean they're right. Ownership isn't a feeling, it's a record. And records don't bend to confidence, pressure, or time. They wait. And if you think this couldn't happen again, the final chapter might change your mind. You'd think a case like this would scare people into doing things right, but some lessons only stick when the cost is remembered. Months after everything settled, I was invited, quietly, to speak with a regional planning review group. No cameras, no press, just a long table, a stack of notes, and people who suddenly cared very deeply about how mistakes happen. They didn't want drama, they wanted prevention. They asked me to walk them through the moment I realized something was wrong, not the court battle, not the ruling, the first signal. I told them the truth, it wasn't the houses. It was the confidence. When people are absolutely sure of something they've never verified, that's where problems begin. We talked about assumptions, about how one unchecked approval can cascade into thousands of decisions, about how responsibility gets diluted when everyone relies on the person before them, and about how dangerous it is when everyone's done it this way replaces written proof. One official admitted something that stuck with me. He said, "We don't expect someone to let it go this far." That sentence explained everything. The system wasn't designed for patience. It was designed for pushback, for early resistance, for quick disputes that could be smoothed over. It didn't know what to do with someone who stayed quiet and documented everything. That's why it broke. After that meeting, I received messages from people I'd never met, surveyors, clerks, even junior developers, thanking me. Not for winning, but for exposing a weakness they'd always felt but never seen proven. The case became a reference point, passed around in training sessions and internal memos without my name attached. And that was fine with me, because the goal was never recognition. It was correction. If there's something unsettling about all of this, it's how easily it could happen again. Different land, different people, same shortcuts, same confidence, same belief that no one will notice. Until someone does, I still own land. I still read every document twice. And I still believe most people don't intend harm, they just underestimate consequences. But intent doesn't undo impact. What protects ownership isn't aggression, it's awareness. So if you ever find yourself dismissed, rushed, or told something is already settled, remember this: settled doesn't mean correct, and quiet doesn't mean powerless. Sometimes the strongest position is simply standing still and letting the truth catch up. Because the next time someone builds on certainty instead of proof, the outcome may be even harder to undo. If this story felt unbelievable, that's because most people never imagined the ground beneath them could legally disappear. Looking back, the most dangerous part of everything that happened wasn't the construction, the paperwork, or even the courtroom battle. It was the assumption, shared by dozens of professionals, that someone else had already checked. That quiet belief carried more weight than any document until it finally collapsed under scrutiny. This experience changed how I see ownership, authority, and trust. Not in a cynical way, but in a sharper one. Systems don't fail loudly, they fail politely. With stamped papers, confident voices, and phrases like "this is standard procedure." And once enough people repeat it, the illusion becomes reality, until one fact refuses to cooperate. What still stays with me is how close this came to ending differently. If I'd accepted the first dismissal, if I'd panicked early, if I'd trusted confidence over confirmation, any one of those choices would have erased the truth permanently. Not because the truth was weak, but because it was inconvenient. That's why stories like this matter. Not to scare people, but to remind them documentation beats assumption every time. Ownership isn't enforced by volume or urgency. It's enforced by records, patience, and the willingness to let facts speak when noise fails. Nothing about this was fast. Nothing about it was easy. And nothing about it worked the way movies pretend it does. There was no dramatic reveal, just steady pressure applied by reality until the cracks showed. If you take anything from this, let it be this: when something doesn't add up, don't rush to be reassured. Reassurance is cheap. Verification is priceless. Because the moment you stop asking questions is the moment someone else answers them for you. And sometimes they answer wrong. Thank you for staying with this story all the way to the end. If you found it interesting, helpful, or even unsettling, that means it did its job. Thanks for watching. If you enjoy stories like this, realistic, thought-provoking, and grounded in real-world themes, subscribe to the channel so you don't miss the next one. Don't forget to like the video and comment your thoughts below. I'd genuinely love to know what you think. Because the next story might make you question something you've always taken for granted.